things about this case that when I looked at this case and did the brief and read the case was that, the jury came back on this case and convicted Mr. Suggs only of a kidnapping charge and on an assault charge and a not guilty on a felonious assault, a not guilty on an aggravated burglary charge. And I found that conviction unique in my mind because that shows to me that there was a question about the manifest weight, how I look at it, the defense perspective on the kidnapping charge. It seems to me that there was a question as to the severity of the harm and what was actually happening at the time of when this woman was in the bathroom with the defendant in this case, and what the jury thought was occurring. The reason why I talk about that is because one of the things that we're arguing in this case is that, and I apologize, but one of the things that we're arguing is that the elements for the kidnapping charge were not met, and that the elements that were there were not satisfied. The other issue in this case that I thought very interesting is the prosecutor's behavior under rebuttal and closing statement. And by behavior,
Well, before you get to that, maybe you could specify which elements of the kidnapping charge you felt were not met.
Your Honor, when I look at the kidnapping charge, and I apologize if I read it, because I tried to memorize it and I haven't been able to memorize it. One of the issues is that it talks about another person is found to restrain the liberty of another person or to facilitate commission of any felony or flight thereafter. And that's what I'm talking about also in terms of to inflict serious physical harm on the victim or another. And what I think is that the evidence from the jury suggested that there was harm, not serious physical harm, as a reflection of the felonious assault not being found, there being a not guilty on the felonious assault. So that's what I'm trying to express is I think there's a discrepancy here about what the elements are of kidnapping and what the jury found with respect to the assault, and on the particular elements that I'm talking about, to facilitate the commission of any felony or flight thereafter, to terrorize or to inflict serious physical harm on another. Where this comes into play, I think, is the prosecutor's comment at the rebuttal that my client was trying to kill the victim in this case, and I believe that to be improper. There was a objection, there was a motion for a mistrial to be made, and obviously the issue for a mistrial has to be whether or not there would have been an outcome, or it would have been a substantial or affected a substantial right of the defendant, and I think it would have. In this case, the prosecutor said that my client was trying to kill this person, he wasn't charged with that. Of course, there's no charge of aggravated murder charge or anything of that nature. And the officer, what happens in this case is the jury then hears that my client is trying to commit a commission of a felony, which is one of the elements of the kidnapping. Murder is, of course, one of the elements, is a felony and one of the elements of kidnapping.
Well, the state in its brief says that that the victim testified that your client told her that he was going to kill her.
The victim did testify to that, Your Honor, and
so how would it be proper for the state to argue that in closing if that's input in the evidence?
well, I think the state is guided by its charges, and I think the framework of a case is defined by what the state charges. So in this case, we have situations, unfortunately, where where individuals say inappropriate things to people and threaten people, and say they're gonna do certain things to people, but they're not always charged with, murder if something happens subsequent, in terms of a premeditation. The framework of what the state is limited to and restricted to is determined by, I believe, and what the state charges. When they charge a certain crime, they are setting the framework. They are limited to those facts that are, or that facts that are within that framework, especially in closing argument. When in this situation, they're suggesting it was that my client would have killed him, and I'm not, and that's, thank God, that didn't happen, but I'm saying that there wasn't a charge. So that's where I think the improperness in this case, and I think it's reflected because when the jury came back with the not guilty on a felonious assault, it came back in this case, Your Honor, with the not guilty on an aggravated burglary charge, and it came back with a guilty of a kidnapping charge. It did come back with a guilty on kidnapping charge. That's where I'm talking about the state interfering in this case inappropriately in the closing, in the rebuttal. And that's where I think that my client's rights were substantially affected. Substantially affected because if the estate does not make reference to that, does not say something like that, doesn't have to say that, then it would have been a conviction of kidnapping in this case. This court itself has talked about what the prosecutors can talk about in a case for State Gabrielli, which is a case that this court has issued. And one of the things it talks about is efforts of the state to obtain a conviction by going beyond the evidence which is before the jury. And in this situation, I believe that's what happened on that closing. That the state, in trying to obtain a conviction on a bad case, went beyond the evidence which is before the jury.
But we just said the evidence before the jury was that he said he was going to kill him.
But I think the framework of that is, there's a restriction from that. The evidence that is proper for them to be continued in terms of that evidence is the evidence only to the charge.
So the fact that your client was not indicted for murder would restrict the state from commenting on any intent to kill.
Right. You said it better than I wrote it by a long mark. Sorry. Your Honor, I do want to talk, if I could, briefly about the issue on the jury verdicts in this case. On the kidnapping jury verdict, there was no listing of the charge in terms of the level of the charge. And I believe under Pelfrey that makes that jury verdict invalid. This court has ruled on a couple of cases, and the one before me for sure, I know Henderson case that I've looked at many times, that it doesn't apply to kidnapping charge. I would ask this court to reconsider that, or to consider that, because I have been unable to find any Ohio State Supreme Court case that supports that proposition of this court. And the kidnapping charge is a very unique charge. The prosecutor in their brief suggests that there's an affirmative defense of the state, of the defense, by providing testimony that the defendant, or the victim was let out in a safe place. Now, I think that's inappropriate because, first of all, I don't think that's an affirmative defense.
You think that the state has an affirmative duty to
Well, I think that, well, I'm not too sure that I totally believe that, but I don't believe that we, as defense attorneys, have an affirmative duty to prove, to put on the evidence of any nature in terms of there being a release from a safe place. It seems to me that it's switching the burden, that if we are responsible for putting evidence on, that the burden has shifted. And especially if you're charged in a case, and I think in F2 in